It is an honor and a privilege to be with you on this precious occasion. I would like to thank you all who contributed to making this event possible. And I will start with an interview uh, made by Rob Attar, the editor of BBC History magazine, who speaks to historian Lawrence Rees about his book, The Holocaust. And I'm just gonna quote from the website historyextra.com. He just starts with the interview with a good example of this for me was former SS member Oscar Groening, who we interviewed for our Auschwitz series. We asked him how the Nazis could murder children, and he said that enemy wasn't the children, but the blood in the children that would grow up to be a Jew. The reason they felt justified in their acts, and Himmler explicitly said this in a speech in 1943, was that if you just killed the adults, the children would grow up to be avengers and they would come up after your own children. So if you really loved your children, then you should kill their children. If you were brave enough, you would have solved the problem for all time. I think that was the kind of stuff that was going on in their heads. When you consider, I just want to share some numbers. In Turkey, the Turkish government, persecuted people as the perceived members of Gulen or Hizmet movement, and the numbers given by the authorities, the Ministry of Justice, for example, or the Minister of Interior Ministry, they give the numbers like as of I think it's 20 June 2022. The number of people detained after the coup attempt of 15th July 15th 2016, the number of people who were detained, 300,032. And as of October 6, 2023, 253 people have been prosecuted for membership in a terrorist organization following the coup attempt. The number of people who were convicted of being a member of armed terrorist organization is 122,000, and the number may differ according to the official statements by the Turkish government. But this figures you can see the figures. Hundreds of thousands of people were prosecuted or subjected to criminal proceedings on bogus or trumped-up terrorism charges. How this happened, what is the background of the case? Background of the case goes back to the famous or notorious corruption investigations of 17 or 25th December 2013. There was a criminal investigation into the corruption in which some members of the government involved, ministers involved, and Erdogan's family members involved. Erdogan, when the corruption cases or investigations started, he called these investigations or cases as an international pilot, international frame to bring his government down. But in fact, when you look at the cases, you can see that all the facts of the case or the evidence, was later proved in cases like the main actor in this case went to the United States, and he cooperated with FBI, and he gave all the evidence to the FBI, and the charge and the evidence all authentic, and proved that there's a huge corruption and millions of dollars, of bribery involved in this case. But it doesn't matter for the government, and the Erdogan, immediately initiated a relentless, very cruel war against the perceived members or the supporters of the movement. And he called them as the assassins, religious deviants, grave robbers, blood-sucking leeches, vampires, the chaos gang, like that. And this a stigma attached to the movement or the supporters of the movement, that fetalized terrorist organization. So the members of or the supporters of this community all are called as the members of an armed terrorist organization. And I will just talk about how these, investigations, criminal prosecutions, criminal trials, which ended up with, the conviction of tens of thousands of innocent people for their all, purely lawful acts. How this happened, and how the European Court of Human Rights, within the framework of the European Convention on Human Rights, responded all these kind of practice, which led to the or amounted to the crimes against humanity, as suggested by the United Nations Working Group on arbitrary detentions. In a number of cases, the United Nations concluded that these numbers, or the pattern of this kind of practice, suggest that the detentions or the practice has amounted to the crimes against humanity. And I just want to share some of the cases, and after this dehumanization and demonization period, hundreds of thousands of people are subjected to criminal investigations, criminal trials, and tens of thousands of people are incarcerated, imprisoned based on these charges. And the European Court of Human Rights, in a number of cases, I think more than 30 cases, but involving more than 1,000 applications, because it combined hundreds of applications into just one application to decide the case, to conclude the case. And the court, decided in, for example, Turan and others' case, the case was brought by, I think, more than 400 applicants of judges who are judges and prosecutors from different courts, including the Supreme Courts. And the court combined all these applications into just one application and one case, and it concluded that the Article 5 of the European Convention on Human Rights, the right to liberty and security of person, this article was violated because the government interpreted the principle of flagrante in delito, the principle of red-handed, and the European Court of Human Rights didn't delve into the facts of the case or the details or the very important allegations in the applicant's cases, complaints. It didn't examine all these very important or serious complaints, because it simply said that its machinery, it was not suitable for this kind of detailed examination, because there was a systemic or widespread violations, and it cannot, simply examine all the complaint in individual cases or applications. This kind of practice by the court, suggested that the court is not an appropriate body, or its machinery is not an effective and appropriate body to deal with such widespread or systemic violations of human rights, which has amounted to crimes against humanity. In that respect, unfortunately, the court sidestepped, prevaricate the important issues alleged or asserted by the applicants in their individual applications before the court. However, despite all these negative aspects of the European Court's practice, the court seized the opportunity to address the core issues, underlying all these prosecutions and criminal trials in Yelchinkaya case, recently decided on 26th of September this year. In this case, the Grand Chamber, on the relinquishment of the chamber, concluded that the applicant was a school teacher. The evidence used in this case was that the applicant used BILOC application program, a chat application program. The applicant had a bank account at a bank. The applicant was a member of a trade union and association which affiliated with the movement. All these, the government focused or stressed on the applicant's use of BILOC application, and the government, simply said that if someone used this application, which was exclusively used, according to the government, by the movement members, the community members, and they automatically, without any consideration, without whether they committed any unlawful acts, or even in case where there's no IDs, there's no content of the speech they shared or communicated, whom they communicated with, it doesn't matter all the absence of, all these information. It just satisfies the Turkish courts, if the applicant, was named by the intelligence service as the one who used or downloaded this chat application, he automatically becomes an armed terrorist. And the courts, it is left nothing for the courts to decide, other than convicting this person of being a member of an armed terrorist organization. This weird and bizarre way of practice and interpretation by the Turkish authorities, of course, was not and is not recognized by the European Court of Human Rights. The Grand Chamber said that these are all the evidence or the acts attributed to the applicants are all lawful acts, and there is nothing in the commission of these acts to suggest that the applicant might have committed a terrorist crime with which he was charged by the courts. On the other hand, the court found that the principle of nullum crimen nulla pena sine lege, the principle of no punishment without law, which was provided for under Article 7 of the European Convention on Human Rights. This principle was violated in this case because the applicant, did not commit any criminal act, as it is clearly seen in his case. On the other hand, the court concluded that the right to a fair trial, the applicant was also violated in this case because the court didn't hear his arguments. The court just, turned a blind eye to his defense and just practiced what, let's say, the intelligence service, decided about him. And the court also concluded that his right under Article 11, namely the right to freedom of assembly and association, was also violated because being just a member of a trade union or an association, these are all the rights protected by national constitutions, including the Turkish constitution. And these rights are also protected under Article 11 of the European Convention on Human Rights. So the applicant just exercised his rights protected under the Convention and the Constitution. So there's nothing in his case suggesting that either these impugned association or trade union or the applicant, by being a member of or joining these associations or trade unions, committed any unlawful acts, let alone committing an act of terrorism. And the government, what does the Grand Chamber's decision in this case, in Yalchinkaya case, mean? What is the significance of this case? I think the significance of the case is, first thing, the case was decided by the Grand Chamber of the European Court of Human Rights upon the relinquishment of the chamber of the court. Namely, in other words, the case was decided by the highest organ of the court. The decision, has become final when it was announced. Second, the case gave the court full opportunity to delve into, to examine the underlying questions of the cases that would guide not only the chambers of the court, but also the Turkish authorities in the similar cases, in the similar tens of thousands of cases, because the court in this case clearly stated that the practice is not just peculiar to this case or an accidental one or an isolated case, but it is systemic, it is widespread. So thousands of other cases, maybe 100,000 cases, the court stated this in this case, is a similar case involving a similar fact, and the government should take immediately the necessary measures to deal with all these injustices, or let's say the persecution of these people. And in brief, we can say that based on this, the European Court's decision, Turkish government imprisoned thousands of individuals who committed no criminal act at all. And all these tens of thousands, maybe hundreds of thousands of people were subjected to criminal trials on purely bogus charges and with political motivation. And what is the relevance of the European Court's judgment to the Commission of Crimes Against Humanity? I think there is no independent at the moment, but there is initiatives to prepare an independent convention about crimes against humanity. But now we have the Rome Statute, and its Article 7E of the Rome Statute directly relates to this practice, the pattern of practice conducted by the Turkish authorities against a civilian population. And the Article 7 of the first paragraph says, for the purpose of this statute, crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. And I will just pass the other paragraphs and go directly to the E, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law. Now, the European Court's judgments are relevant and important here because it says that tens of thousands of people are imprisoned and they were subject to severe deprivation of physical liberty in violation of fundamental rules of international law because they didn't commit any unlawful acts, they didn't commit any criminal act, they did not commit the crime with which they were charged, and they were imprisoned with political motives. And it is obvious that this actus reus of the crimes against humanity provided for under this article of the Rome Statute clearly indicates that there is a crimes against humanity committed by the Turkish government against this civilian population, because also the mental element, let's say the mens rea element of the crime, is present here because it says with knowledge of the attack. And when you go back the background of the case, you can see the dehumanization, demonizing process directly organized and planned and put forward by the Turkish government and the leaders of the ruling party, including the president and his fellows. This knowledge of attack, the mens rea element, and the actus reus. I mean, there are torture cases, kidnappings, and persecution if you take it as an independent factor. But you don't need to take all these into account. You can just see and read the paragraph E under paragraph E, imprisonment or other severe deprivation of physical liberty. And it's obviously there, present all these actus reus element under this paragraph. Thousands or tens of thousands of people were convicted on bogus charges, for their purely lawful acts, and tens of thousands of people were deprived of their physical liberty in violation. Now it's clear under the Yalchinkaya judgment of the Grand Chamber's judgment in violation of fundamental rules of international law. And I just want to say a few words about the Turkish, the reaction of the Turkish authorities to the Grand Chamber judgment. And we can still follow the news and see that hundreds of individuals have been arrested. Thousands of cases have been affirmed by the higher courts, despite the ruling delivered by the Yalchinkaya judgment that states convictions are a sheer violation of basic rights of the people, concerned. And Turkish government's practice, as brief, Turkish government's practice of crimes against humanity continued to take place despite the European Court's Yalchinkaya judgment. This pattern clearly demonstrates that the Turkish authorities are determined to commit the crimes against humanity in the absence of a strong sanction, which might hold the individual perpetrators of the crimes against humanity accountable for their crimes. And this is expected from the Committee of Ministers, the political organ of the Council of Europe. But there should be some other maybe initiatives to make the court more effective to deal with the widespread and systemic and systematic gross violations of human rights. Thank you very much for listening to me.